Thank you. As I said, we're now going to throw to the panel, and just so everybody knows who everybody is, Julianne, Michael, Bill and Stephen. Just before I do throw to the panel, and I think, Luke, you said there's a... Yes, you've got a roving mic to assist people to hear. But just before I do, I know Michael just wants to say one thing briefly about, I think it's assessments.
Yeah, I just wanted to add to what Julianne was saying, that an assessment for most enterprises will be material to the enterprise. In a small enterprise, most amended assessments that I deal with, it's material to the existence of the enterprise. That is, if the Commission is correct, the enterprise will be at end, at least in its current form. And even in larger organisations, I don't know, take something like the RCI case, the assessment from the Commissioner will be the single largest dispute that the organisation ever has in its existence. And the issue of the assessment itself, it's sometimes forgotten, of course, crystallises not only the taxation liability, but the existence of the debt that exists, that's unchallengeable otherwise than under the Part 4C proceedings, will have accounting ramifications, will have solvency ramifications, and so on. And for example, you know, an ASX-listed organisation may well have to give notes to the account. It's going to have to adjust profit forecasts. A smaller organisation, more likely solvency issues because of the debt. And it's important that the tax practitioners, who sometimes lose sight of those consequences, don't, because they're even more important than the objection process itself and have to be dealt with really the moment the assessment is issued. Because it becomes due and payable, it's unchallengeable effectively, and therein lies the problem.
So just to add to that,
Yeah,
it is open for the Commissioner not to commence recovery proceedings, but to go straight to the statutory demand procedure. I do have a case presently in the Federal Court which was just heard an appeal. We made an application to set aside statutory demand. The application failed, and the appeal was just heard on the 7th of November. But I'm just saying that the Commissioner does not need to commence recovery proceedings. He can go straight to the winding up of the company if that is permitted.
all right. Now, please feel free to ask questions, raise issues, and I'll throw the floor open to you people. Come on, don't be shy. All right, well, nobody wants to...
Can I say something, Brind?
You most certainly may.
I have a question, or I'd like to throw something over to Stephen. He was just telling me in the break about circumstances that he's come across in which the Commissioner will contest an application to amend grounds. And I thought you might like to share it with everyone rather than just me, Stephen.
As Julianne said, usually the Commissioner will either agree to, or at least oppose an application to amend the grounds of objection and thus amend the scope of what the taxpayer can argue for in the AAT or the Federal Court. In my experience, there are three circumstances in which the Commissioner might not agree and may oppose such an application. The first is whether the new proposed ground is demonstrably hopeless, and that is that the Commissioner can demonstrate that it cannot succeed for some obvious reason. And the argument there would be, well, there's no utility in allowing an expansion of grounds to run an argument that cannot succeed. The second would be where the taxpayer is is out of time by a long period, particularly where issues as to witnesses' recollections may come in issue. So I did a case involving PRRT assessments, which I think 2003 and 2004 were within time, but the taxpayer wanted to have an extension back to 1990 to bring in another 14 years worth of objections that were out of time. Now, the Commissioner resisted that on a number of grounds, including that the ground couldn't succeed, but also that there was no proper explanation for the expansion, and it would prejudice the Commissioner because of the need to look at documents and basically trawl up 14 years of history. So that's the second situation in which the Commissioner may not permit an extension. The third situation is where the thrust of the new ground is that you've assessed the wrong person. So the taxpayer may admit there's a tax liability, but it shouldn't fall on me, it should fall on that entity over there. If the Commissioner is now out of time to assess that other entity, then the Commissioner would be prejudiced by that argument, because if the taxpayer had made that argument within time, the Commissioner may have issued an assessment to that other entity. So that's the third situation in which the Commissioner would resist. There's a prejudice to the Commissioner in you not having identified that argument within time. But these are pretty much the exception. Usually the Commissioner, particularly if he thinks it's a bona fide dispute, will not oppose expansion of the grounds of objection.
There is a fourth ground, a fourth reason, and I'm unable to tell you what it is, and probably no one else can identify it. I appeared in a case for the taxpayer which I was opposed by my learned friend. We sought to introduce and rely on a further ground. The Commissioner opposed it, and we were successful in introducing this further ground, and we relied on it. What was interesting is that the case then went on appeal to the federal court. The Commissioner then sought to introduce a further and a new ground of disallowance of the objection on appeal, and the Commissioner was allowed.
Yeah, can I just say the addition of grounds of objection is governed, that weren't in an objection, is governed by Lighthouse Philatelics and the Commissioner of Taxation, which was the case that came down after the amendment to the then Section 190B of Part 5 to allow new grounds where the court or tribunal gave leave. Just as a note, that the reasoning in that case predates ANU and what's the case about amendment? It's founded on the same principles as amendments of pleadings, and those principles have since been affected, of course, by the introduction of the Civil Procedure Acts and the High Court in the ANU case, and query whether those principles will be revisited should the matter ever come before an appellate court.
I mean, from the other point of view, the Commissioner can rely on any ground in the AAT. He's not limited to his objection grounds, but if he's going to raise something new, he has to give the taxpayer proper notice, which he usually would do by putting in his statement of facts, issues and contentions, or issuing an amended statement of facts, issues and contentions. So there's just a sort of a natural justice ground to ensure that the taxpayer is alerted to the fact that the Commissioner is now, as he frequently does, because usually the Commissioner may know a lot more about the taxpayer's case by the time it's in the AAT than he did at objection stage. So it's quite common for the Commissioner to come up with new or alternative bases for disallowing the objection.
And another reason why that often occurs is that with each stage through the tax office, new people are becoming involved. There's the original auditor who's involved in the assessment, then there are separate officers who are involved in the determination of the objection, and then if it keeps going further, it then reaches the legal services branch, it might reach the tax council network, it starts going to council, and that's another reason why, as well as more information being known, just more people looking at the issue, and that can also often give rise to new grounds being raised in the statement of facts, issues and contentions, or the appeal statement in the court. And sadly for the taxpayer, there's not a great deal that they can do about it.
Well, on that, if I can just add, it raises one of my pet hobby horse where I do disagree with Julianne, and that is, what is a ground? Take a valuation case, I don't know, sale of shares, and there's an argument about the valuation case. The ground is that the value of the shares used by the Commissioner was too high. The valuation relied upon the taxpayer, which may be annexed or exhibited or attached to the objection, the content of that is not a ground. That's evidence of the ground that's been put forward. And it's a drafting question, but it does have ramifications where amendments are later sought, because it's one thing to say that in an objection that the valuation was too high and it should have been something lesser, which presumably would encompass any valuation that's lesser that a taxpayer could put forward, or simply attaching a valuation and saying that was the correct valuation, in which case the taxpayer has bound themselves to a particular term. I agree with Julianne that objection should be made as useful as possible by containing as much information that's been wishing to put forward, including accompanying materials, but I don't know that it necessarily follows that everything that's included forms part of the grounds of objection. And I think some care needs to be taken in drafting to distinguish between what's a ground and what's an argument in support thereof, or evidence in support thereof.
Yes, I agree completely, and I actually have a matter at the moment which involves a valuation issue, and that precise thing occurred. The objection stated that the Commissioner's valuation was too high. It's a CGT issue. And the objection did actually say, we think it's too high, we think the value should be this, but it was not until the issue reached the court that expert valuations started to be provided, and the Commissioner has not at all contended that there's a change in grounds. The Commissioner accepts that the original ground was that the Commissioner's valuation is wrong. And a new valuation has now been provided by the taxpayer, and that's not a ground, not considered by any party to be a ground.
One of the more contentious grounds is whether in your objection you can say, or you can put in one of the grounds is that the assessment is not valid for whatever reason. The Commissioner's approach is to simply say that this is not a matter that can be raised in objection, I'm not going to deal with it, and that's what they say in their objection decisions. As a general rule, sometimes they deal with it in some more detail. This is a question that is, according to the Commissioner, presently open. I do have 2 full federal court appeals listed in the first sitting next year that deal with this very question, and that is whether or not in a Part 4C proceedings the federal court is seized of jurisdiction to determine whether or not an assessment is valid. In Part 4C, normally validity is tested in 39B proceedings, but I sought to test it in Part 4C proceedings, and that would be a matter that would be determined by the full court. Hopefully we'll get the decision that we're looking for there.
Well, has that raised any issues for members of the audience to ask? No. All right, well, I want to throw an issue to the panel for their views, and it's because I do think it's something that Julianne raised towards the latter part of her talk, but I do think that the Commissioner is trying to avoid court proceedings, avoid AAT proceedings if possible, and I think that's a very good way to go for a variety of reasons which I'm not going to go into. But I would like to hear from the panel as to their views as to how effective ADR actually is.
I've had a lot of experience with ADR with the Commissioner. None, I must say, at the objection stage. It's all occurred post-issue in the tribunal or the federal court, but I've also had some success pre-issue of the assessment. And if you think about the Commissioner's processes with the GAR panel and their internal transfer pricing panels where taxpayers are sometimes allowed to have representation, there's some informal fraud and evasion panels I think that exist in the practice statements that I'm aware of cases where the Commissioner's allowed presentations to be made by taxpayers at those stages, and they've effectively acted as de facto dispute resolution because the parties have got together to discuss the issues in a structured forum where a senior taxation officer, admittedly internal, but still someone who is independent within the ATO, has considered both arguments and come up with a position. And look, sometimes I've been in ones that have been successful, and others the Commissioner's declined to change his opinion, and it's gone on. But it's been highly successful because of the structure that surrounded the way that it operated, where there was a formal decision maker and there were formal presentations made. I don't see any reason why that couldn't extend to the objection stage. The only caveat I have, of course, is that if assessments have issued, then someone with appropriate authority in the Commissioner's office has made a decision that represents the Commissioner's position. So I don't know that it creates the correct timing issue for resolution, because it's at a stage where a decision's been made, but theoretically there's no reason it couldn't happen.
Can I just say, just on that, I've had experience in a fairly large audit where it was obviously there was going to be a big fight if assessments were issued, and after position papers and responses had been exchanged, it was agreed that there would be ADR because everybody could understand what the issues were, and that has been a very, very successful way of resolving issues, and it's something that I hope we can see more of in the future. Sorry, Julianne.
No. I was just going to say that I've always found ADR very helpful. I've normally been acting on the side of the Commissioner, but I can see from the Commissioner's side that the helpful aspect or the helpful thing about ADR from the taxpayer's perspective is that you do get a decision maker in the room. And if you are able to get the Commissioner to agree to either mediation or some form of neutral evaluation, then the Commissioner is taking the issue seriously, and you will get perhaps more senior officers in the room with you to resolve an issue. And that can only be helpful if your aim is to resolve an issue, which frankly I always think it should be, because as soon as you walk in the door of a tribunal or a court, no matter how strong you think your case is, there is no way that you can be certain you're going to win. Anything can happen in a tribunal or a court. I was involved in an early neutral evaluation earlier this year, which was a very large issue and involved a ruling request. The ruling request had not been determined, but the taxpayer and the Commissioner agreed that it would be appropriate to put this issue before a third party, and in that instance the third party was a retired judge. There was a contract between the taxpayer and the Commissioner as to how it would run. The Commissioner, nobody made any commitment to be bound by the decision, but the process was followed through in good faith. And as it turned out, the parties were satisfied with the decision, and the issue went away. It ran precisely like a court hearing, except that nobody stood up in a room such as this one, with counsel for both parties and submissions being made, witnesses, cross-examination of witnesses. But it was a process that was controlled by both of the parties, and it had a very good resolution. Now, if you do have an issue which is able to gain the attention of the Commissioner and lead to a process like that one, it can be very, very good, but that was an exceptional matter. I think, and my experience with mediation, as I said earlier, is very positive, because as soon as you have mediation, you have a decision maker in the room and you're dealing with somebody more senior.
There's somebody down the back there, I think, wanted to ask a question.
Oh, yeah, Julianne, did you get a written decision in that early?
We did. We actually had a written decision, but obviously also the benefit of this process is that it's all confidential, completely and forever. And obviously the decision won't be any precedential value, even though it's very interesting to read.
Did it read like a normal judicial?
It read like a decision. It was written by a retired judge, and I was involved in one of these, and I understand there's been at least one other instance in which the Commissioner has followed this process. But as I say, you'd have to lobby hard for it, I think, and it would have to be an issue which is very significant.
Can I just say something else? The purpose of ADR is not necessarily to resolve a matter. It can be used, and I've used it extensively, to narrow issues. Yep. I think in one or two cases I've been involved in, we've narrowed the issue down to the point where the Commissioner decided it should be funded by test case funding, because all the facts that were in dispute actually fell away when it was properly analysed, and it was just a question of law between the parties, which the Commissioner thought was important. The other thing to note, and I think maybe from the Commissioner's perspective in not resisting these sorts of ADR processes, is many smaller taxpayers, all they want is to be heard by an independent party. If they lose, they'll pay up and pack their bags and go home, and they don't really want to go to court or the tribunal. They just want to feel they've had a fair hearing from somebody who isn't in the Commissioner's office. And I've been involved in quite a number of the smaller ones where we've had a conciliation down at the tribunal. I think mostly Bruce Pascoe came in and said, look, I actually think you're going to lose, but if it were my position, I'd knock back the penalties 10%. What do you think, Mr. Commissioner? And the Commissioner says, yeah, all right, we'll drop the penalties, and everybody went away, and we knocked it off in an afternoon instead of a 2 or 3 day hearing. And sometimes I think from the Commissioner's office there's resistance to the ADR because they don't see the point, and quite often the point is that all the taxpayer wants is to tell their story to somebody who isn't in the Commissioner's office.
I agree with that completely, and with the right mediator who's able to lend a sympathetic ear, once that's done, it can all be resolved. In fact, it's surprising how many can be resolved in that way. Ones that you would never think could be end up being resolved.
Anybody else on the panel?
I would feel the same experiences. Yes, I think ADR can be quite effective.
I cannot, well, as a counterpoint, I can think of a large dispute we're involved with in which we had 3 mediations prior to the objection being issued, including retired High Court judge presiding as a mediator, at which the parties remained a very great distance apart. Proceedings were issued in the federal court, and it was ultimately settled on the Friday night before the Monday where a 6-week trial was going to start. So, for all the best will and intentions in the world, ADR doesn't always work. No. It didn't narrow the issues in that case. The parties were a long way away. It was only the pressure of the looming trial that forced an answer. But more often than not, it can be helpful. And certainly in the AOT, my experience in conciliations, particularly when you've got Mr. Pascoe, or one of the members who's prepared to sort of more forcefully state their point of view, and more often than not, in my experience, conciliations have been successful in the AOT. So, but that's obviously at a later stage than an objection.
Well, I'll throw one other to the panel if I can, because it's something I've always found of some interest, and I know it's something that particularly worries some clients who wish to maintain anonymity, but that is whether you go to the tribunal or the federal court.
It'll have to be the tribunal.
Why do you say that, Bill?
Well, the tribunal does have the power to go through the whole case without identifying any of the parties. And that's an instance when you have, names like X, Y, Z and such like. But then if you don't like the decision and you want to appeal it, as I had one instance, then in the federal court the name of the party will come out. And that's one of the reasons why they did not proceed to appeal, even though they didn't like the decision.
And I've had the contrary. We've won, and the Commissioner wanted to appeal, and my client rolled over to protect their anonymity. And it was all a waste of money. So I think my own view on that is it's a silly reason. If you're going to engage in a dispute in a public forum, to try and protect your anonymity is a bit of a silly reason to make a forensic decision about what forum you're going to litigate in. There are other more important reasons. And having I've heard the argument many times about this question of, is there a discretion to be exercised, is there to be a merits review, the Commissioner stands in the shoes. Putting aside the penalty question, where the tribunal has been very active over the years, I challenge anybody to find a case where the tribunal has said, there's no error of law in the Commissioner's decision I can discern, but I'm going to re-exercise the discretion, and I'm not going to find it's evasion, and I'm not going to find it's Part 4A. It just doesn't happen. The reality is, unless the Commissioner has really made a blue, and it happens from time to time, you're not going to get that decision overturned in the tribunal or the federal court, and it's a bit of a furphy, I think, to say that just because there's a discretion involved, you must go to the tribunal. I mean, it's the obvious choice, but you should consider the prospects of actually having the discretion overturned on the merits, which are extremely low. It's far more likely that you'll be successful, if you're going to be successful, on the substantive grounds that are in dispute in respect of it, that the tax wasn't owing and hence it wasn't evasion, for example. And I just think, people are in too much of a hurry to make that decision for grounds that are really pyrrhic.
Sorry, there's a question down the back there.
Perhaps on a similar note, what type of cases would you take directly to the federal court rather than going to the tribunal?
In my view, if there's no exercise of discretion involved, and there's also some questions of costs involved, which I also think are a bit the cost savings that are said to exist don't really exist, then one would go to the federal court you skip a level of appellate process, you get a judicial decision maker, particularly where facts are in dispute or it's an evidentiary case. Certainly if there's any difficult question of law and there's no overriding sort of discretionary type of concern, you'd be much better off going directly to the federal court.
Other instances is when you're trying to lead inadmissible evidence, you go to the tribunal.
But I mean, that can cut both ways. I mean, the Commissioner may well have documents, particularly these obtained from third parties, that he may have a great deal of difficulty proving under the Evidence Act, but which are automatically in the AAT simply because they're in the Section 37 in the T documents. And so that evidence thing can cut both ways. The other factor I would take into account, particularly when acting for a taxpayer, is that things move at a much greater pace in the federal court. You get the Commissioner's appeal statement, you put your appeal statement in, two weeks later you're in front of a judge, and if it's some of the more energetic judges, you may be asked a lot of questions about, are you ready for a trial? I mean, I've seen people have been asked, well, I've got next Friday off, let's have a trial then. Or they'll certainly be aiming, because one of their statistics is the number of matters they clear up within a year, to have a trial within 9 months and a decision within a year. So, and the timetables are much tighter, and the consequence of not complying with the timetable is a lot more serious. In my experience, things move much more slowly in the AAT, and the consequence of not complying with the timetable is the AAT registrars may huff and puff, but you really have to...
They don't do anything.
Yeah, You really have to be in default multiple times before they'll even start thinking about throwing your proceeding out. So if you've got this can cut both ways. If you've got a taxpayer who you have had, your dealings would indicate that they may not have much money, or that they're slow in providing information to you, and you have a concern that they will not devote the time and resources to a quick hearing, you may be better off in the AAT. On the other hand, if you're a taxpayer and you've got the resources, you've got the money, you know what your case is, you've probably done the work to have your witness statements ready, you can put quite a lot of pressure on in the Commissioner by turning up to that first directions hearing and saying, well, we can file our witness statements in 2 weeks, we're ready for a trial in 6 weeks. And that can put a great deal of pressure on the Commissioner, who may not have those resources, may not have that time. So the choice of which way to go can often be determined by how well resourced and ready and energetic your client is, and the tactical advantage of forcing things on quickly as opposed to holding them off.
Can I just come back to the objection stage too? I mean, a case that would go to the federal court is one that you've probably contemplated going there at the time that the objection was drawn and settled. I mean, and the reality is that if you've done all that work, you've got a much better prospect in having the objection allowed than if sort of the evidence is left until after the Commission has disallowed it. And one of the underlying themes, or I guess it's an underlying assumption of the federal court practice statement that causes these matters, the tax matters in particular, to be treated as fast-tracked, is it's assumed that everybody's advised by competent counsel and competent lawyers and competent accountants prior to the objection stage. At the audit stage, so everybody knows what the issues are, hence there should be no difficulty in putting on evidence.
There are a lot of, I suppose, tactical decisions why you would choose one or the other, and they'll depend on the facts of the case. Obviously, they are not things that one can say in the open.
No, but there's a few myths around, I think, that need to be dispelled. I mean, we should talk about costs quickly, which is one of the ones that's often raised. Obviously, there's no costs against you in the tribunal if you're a taxpayer, but somehow or other it's thought to be cheaper, and I've certainly in my experience never found that. Your lawyers and accountants and professional advisors are going to charge you the same whether you're in the magistrates' court or the High Court. And the reality is, if the costs of the Commissioner are a concern in the proceeding, you've got to consider whether you're actually committed sufficiently to the dispute to be bothered the proceeding at all.
I think it's a complete myth that the AAT is cheaper than the federal court. The only difference is things go faster in the federal court, so you spend the same amount of money, but you spend it more quickly. In the AAT, it can just be dragged out.
No, so it's also an advantage, because in the federal court, you're going to get on, you're going to get a trial, it's going to happen. Yeah. It's not going to sit around and drag out, there's not going to be multiple amendments and multiple hearings, it's going to happen. And it used to be the reverse, the people went to the tribunal to get on in a hurry because the federal court was so slow. It's now the other way around, and I've certainly got people who are tempted to the federal court just because they know they'll get it over and done with one way or another.
Bearing in mind, of course, that we're talking about matters that involve council. In the AAT, there are a lot of matters which, for some reason or another, strangely don't involve us. People don't brief council, whereas if you go into the federal court, then it would be very unusual that you're not briefing council. So if you have a matter which, for some reason or another, it's not appropriate, you think, to brief council, then the tribunal would be, I would say, the type of forum that you would be looking at.
All right. I'm conscious of the time. It's just on 8:45. Has anybody else got any questions they would like to ask or comments they'd like to make? Feel free. We're not in a rush to bring this to an end, but we all know that we do have to do some work today. All right. Well, can I just say thank you all very much for coming, and thank you to the panel members, Julianne, Michael, Bill and Stephen. I'm sure that you've found it as interesting as I have, because I've certainly had some interesting things to contemplate as a result of what's been said here this morning. And perhaps if you could all join with me in thanking them in the traditional way. Thank you very much.